The United States Supreme Court is considering a challenge that involves one of the most consequential laws that impacts the internet as it actually functions and works in reality today. Section 230 of the Communications Decency Act. The U.S. Supreme Court has never heard a challenge on Section 230, and they're hearing a challenge right now, this term, in Gonzalez v. Google, which might have substantial impact on terms of how the internet functions. So we'll go ahead and read this article and discuss what is happening in this upcoming court case. Noam Gonzalez was 23 years old, studying in Paris, and was killed after individuals affiliated with the terror group ISIS opened fire on a cafe when she and her friends were eating dinner. She was one of 129 people killed during that November 2015 wave of violence in Paris. In the wake of her murder, her estate and several of her relatives have sued Google. The theory is that ISIS posted hundreds of radicalizing videos, including inciting violence and recruiting potential supporters to YouTube, which is owned by Google. Significantly, the family lawyers also argue that YouTube's algorithms promoted the content to whom the characteristics indicated they would be interested. The question, of course, therefore, is whether federal law permits a major tech company like Google to be sued over content its algorithm served up to certain users divides some of the brightest minds of the judiciary. Although at least 2 federal courts have determined the companies cannot be sued, both of those provide dissents, and now it's up to the resolvement of Gonzalez. Okay, so this is all dealing with Section 230C1, right? Basically says that no internet content provider is liable for the publisher of another information provider's content. But if you go look at the relevant definitions in Section F3 for what a provider is, it says a provider is anyone who contributes either in whole or part to content. And so one of the questions you might say is like, okay, wait a second. So if YouTube YouTube or Google or anyone else just allows the content to be posted, that is not them posting. That is not them acting. If they moderate by removing the content completely, Section C2 does that, right? Section C2 deals with moderation and removing of content. But what about this algorithm? What if they suggest something? Well, if YouTube themselves actually just posted it on their own YouTube channel, that would be considered them posting, right? YouTube does have a YouTube channel. Twitter does have a Twitter account. Facebook has a Facebook account. So they can make posts themselves. And that is their content. They're the one posting it. They're hosting it on their own platform, but they're also the one providing it. They're also the speaker. Okay. So if Google doing that, if them hosting content on their Google page, on their Google homepage, or on their YouTube page, or Facebook doing it on their Facebook page, or Twitter doing it on the Twitter page, right? If them making that sort of active human-based decision is implying their action as a publisher rather than as a platform, then if the algorithms are doing it, well, they're in control of the algorithms, right? They're in control of that, and so maybe they need to absorb that liability. That's sort of the legal theory that's in play here. All right, let's read a little bit more about the article. At stake are fundamental questions about how the internet works and what kind of content we see. Currently, algorithms and behind-the-scenes automation determine everything of what we see. I mean, that is definitely true of the modern internet, right? This law was created in 1996, but since then, you know, we've gone from it being human curated to it definitely being algorithmic. In the worst case scenario for tech giants, a loss in Gonzalez could impose an intolerable amount of legal risk for the algorithms. Basically like, well, they're your machines, they're your automatons, so you're responsible for what they do. And if they're promoting content, that's now a decision that you are making, which would prevent their algorithms from recommending any content, basically. Because, you know, it'd be basically borderline impossible to create anything that would satisfy all the concerns. So I think that it would probably prevent algorithms altogether, which, you know, would be a big change of the way how things are operating, at least in terms of the recommendation of content. Like, it would change in that respect. Of course, there is evidence that these algorithms impose a lot of harm or a lot of at least impact on society. In 2018, a sociologist warned YouTube may be one of the most powerful radicalizing instruments of the 21st century because its algorithms tend to pose more and more extreme versions of content. Someone who starts off watching videos about jogging may be directed to ultramarathons. Someone who watches Trump rallies may be pointed to white supremacist rants. So, yeah, I mean, there are rabbit holes to be sure, and people can fall down any number of rabbit holes. And the algorithms will recommend content that fits in with the rabbit holes. So that is potentially an issue. If the United States had a more dynamic Congress, lawmakers could study the question of how to maintain the economic and social benefits of the algorithms while potentially preventing them from serving up ISIS recruitment videos and other kinds of content, and potentially write a law that would strike the balance. But that's going to be really, really hard because although the progressives and conservatives, the Republicans and Democrats tend to agree that Section 230 needs to be reformed, they very much disagree in what way. So we can't do that, so thus we go to court. And the outcome of the lawsuit turns on whether the law that was written in 1996, when the internet looked very, very different than it does today, and how that means it will operate. Although, of course, it's always possible that if the Supreme Court writes a decision that would be disruptive, maybe that will motivate Congress to act. Because, of course, in this case, the Supreme Court is interpreting a statute, namely the Communications Decency Act, which means that no matter what the U.S. Supreme Court does, the Congress can overrule them. Because the Congress can always make a different statute, right? There's the Constitution, if they're interpreting the Constitution, you need a constitutional amendment. If they're interpreting a statute, just make a different statute. So, it's always possible that a really sharp decision from the U.S. Supreme Court might spurn the Congress to act. But, that's banking on a lot, so we can see. There are many reasons to be skeptical the Gonzalez family will ultimately prevail. Even if their lawyers can prove the individual who murdered them watched ISIS videos, it's unclear how they could show causation. And the First Amendment, of course, protects video content unless it's directed to legal incitement. But of course, the litigation never got that far. So even if they win, they have a whole bunch of causality problems. This has never been allowed to be developed. So how do you prove that people who did the attack watched the videos? How do you prove they were radicalized by Google? Right. So, there might be some ways to do that, but that's a whole nother problem for another day. The safeguards imposed by the Communications Decency Act shape the internet as it exists today. And how? It's unlikely social media sites would be financially viable if their owners could be sued every time a user posts defamatory content. Yes. Nor is it likely sites like Yelp or user sections like Amazon would have the ability for users to leave content if they could be sued. Section 230, of course, by its own term, Section C2 specifically, if you want to look it up, protects websites that remove content they find objectionable. Yes, and we can get into the scope of that another time because their ability to do so under C2 is questionable, at least in the way it's being exercised. That C2 gives you a lot of grounds, but not infinite grounds. But this isn't a C2 case. This is a C1 case. So, yes, you have the ability to remove content. That's C2. But it's far from clear it protects websites that promote illegal content. Yeah. If you publish a defamatory tweet and Twitter sends out a promotional email, then you'd have a big claim, right? Yeah. So if Twitter makes that exact decision, you're there. The Gonzalez family argues the YouTube algorithm, or for that matter, the Twitter algorithm or the Facebook algorithm, should be treated the same way as if Twitter itself made an active human decision. That is why Google cannot be sued because it promotes videos. The family claims Google can be sued because one of its websites uses an algorithm that promotes the content. So that's the idea. Google itself, if it made the human decision to recommend the content, like by posting it themselves, that would be Google's responsibility. So by what logic do you say they have immunity if it's an algorithm, since they're in control of the algorithm? Why was the law passed? Well, of course, ordinarily a company that enables people to communicate with each other is not liable for the things other people say. But the rule is different for newspapers, magazines, or other publications that curate what they publish. They can be sued on the basis of republication. So if you're merely transmitting content in the real world, you typically can't be sued. The person who transmits the content. So FedEx can't be sued for its letters it sends. UPS can't be sued for letters it sends. Western Union can't be sued for the telegrams it writes, for example, right? But if you're a newspaper, magazine, or publication that curates and makes the decision what to publish yourself, republication. That's the rule as it existed. Much of the internet, of course, falls into some middle land between the two, which, of course, does not screen content like a magazine. But Twitter routinely deletes tweets it does deem offensive, and sometimes even bans officials or bans content, but doesn't exercise the normal level of editorial control that a magazine or newspaper does. And this is incidentally where the Texas law that we've been discussing comes into play. Because since Twitter is more, well, at least this Texas courts, the Fifth Circuit says, at least Twitter, because it's more like a telephone company, more like Western Union sending telegraphs than a newspaper, because the overwhelming vast majority of the traffic, they don't review or stop, right? So they're more like just someone who just takes it and just sends it out the door. They're more like a messaging service. They're more like a messenger, just sending messages. And occasionally they say no to certain customers, but so did Western Union for that matter. As opposed to a newspaper, which basically everything that's in the newspaper, of course, is selected specifically by newspaper staff. It's all human curated. So that's the whole basis of the Texas law. That was the Fifth Circuit, and why I think at least it has potential if it gets to the U.S. Supreme Court, which it probably will. In one of the interesting ironies of all this thing, this case all goes down to Stratton Oakmont versus Prodigy Services Corporation. Stratton Oakmont, of course, is the company, the financial company that was the basis of the movie Wolf of Wall Street. It was a real company that really existed, really engaged in financial frauds. And it's interesting that Wolf of Wall Street over here brought us a case that was the basis of the entire change of law. So Stratton Oakmont cheated people out of lots and lots of money and also fundamentally created the internet as we knew today. Who knew? Prodigy was a service that fell into this gray zone. It did not curate every piece of content, but it did use some automated screening programs to remove offensive content. And that, by the courts, was ruled to be a level of editorial control. Because they made the decision to remove some content, that was deemed to be editorial control. And 230, of course, was designed to overturn that. So that says that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. And one of the things at issue here, of course, as I mentioned, is section F3, which says that an information content provider is someone who in whole or part creates the content, which then, of course, may be what Google's doing by its algorithms is promoting the content. The Gonzalez plaintiffs effectively argue the website is not protected by Section 230 when it affirmatively recommends other parties' materials, regardless of whether the recommendations are made by a human or a computer algorithm. Although the primary purpose of Section 230 was to allow forums to operate without having to host content, it provides that they are not subject to liability behind any information provided by another information content provider. Given this broad language, a divided panel of the Ninth Circuit concluded YouTube's algorithms are protected. Among other things, the Ninth Circuit argued that websites necessarily must make decisions that elevate some content while rendering other content less visible. Quoting from a similar Second Circuit case, one court explained that websites have always decided where on their sites particular third-party content should reside and to whom it should be shown. But then again, maybe 230 didn't provide immunity in that domain. A strong rebuttal to this argument was offered by Judge Robert Katzman in a dissent in Force versus Facebook, which is a lawsuit that was very similar regarding Hamas. Katzman argued that Facebook algorithms do more than just publish content. Their functions proactively create networks of people by suggesting individuals and groups that users should attend or follow. And thus, according to Judge Katzman, this goes beyond mere platform and into publishing, and therefore should be treated them as a publisher. If Google loses the Gonzalez case, it needs to fear the possibility that it could be held liable for illegal content published by others, at least if the content is promoted by an algorithm. And of course, it then becomes unclear how search engines can even operate without algorithms, and thus what becomes of the internet as we know it. So Section 230 is on trial at the U.S. Supreme Court, not Section C2, which deals with the moderation of content, which also needs a look at, but rather C1, basically, what is the distinction between the platform and publisher of content? The law provides that no internet content provider shall be deemed the publisher of another person's speech, but then, of course, defines what it means to be a speaker to mean to assist in whole or part. And so there is some dispute over whether or not Google can be held responsible, because Google's in control of the algorithms. So maybe Google should be held responsible because it's in control of the algorithms and could, at least in principle, not promote certain kinds of content. Now, of course, in practice, how they would do that is a whole nother set of problems. And as I pointed out, no matter what the Supreme Court does, because this is based on statute, it could be overruled by the Congress, who could pass some sort of a modification. So whether or not any of that will happen is, of course, remaining to be seen. But that brings us to the end of discussion of this article.